We carry around these devices that can actually get us in criminal trouble, right? And for those of you that keep hitting redial when you get a little worked up, that can lead to an arrest for what we call harassing phone calls. Now, Florida law does not say where you cross the line. Is it 50 calls? Is it 30 calls? We have seen convictions for as little as 10 calls. We have seen convictions for like 5 calls, but we have also seen these convictions overturned mostly on the issue of intent. And what I mean is a harassing phone call crime at its heart is the intent to annoy, the intent to harass the person on the other end. So if you have some other purpose in your call, even though that other person might be annoyed, those convictions have been overturned. For example, there was a case where somebody was calling 911 about loud music, and 911 said, we'll take care of it. They called back again because the cops weren't there. 911's like, we're working on it. Stop calling. I mean, 10 times, stop calling 911. Eventually, after 10 calls to 911, after 911 kept saying, please don't call us again about this loud music, they arrested the person, and the person was convicted of harassing phone calls. That conviction was overturned based on the fact that there wasn't solely an intent to harass 911, but rather there was an intent to report the loud music. There was another conviction for harassing phone calls where a politician had convicted a defendant of a crime, and that defendant kept calling that politician's office to say, I'm innocent, I'm innocent. And the politician's assistant said, you need to stop calling here. Well, 5 voicemails later explaining, hey, I'm innocent, the guy gets handcuffs for harassing phone calls. And the court overturned that conviction, again, saying, look, there was not a sole intent to harass and annoy here. There was an intent to explain the defendant's innocence to this politician. And because there was that legitimate theme underlying the voicemails, that conviction was overturned. Believe it or not, harassing phone calls is a bit more complicated. There is no bright line. You can't say, well, 3 calls, 5 calls, 10 calls. We've seen convictions for this on 5 calls, 10 calls, 50 calls. I had a case that my client had over 100 calls, right? There is no bright line. The statute doesn't say if you call this many times, it's a crime. So you have to be very careful when somebody tells you stop calling. Basically, you got to stop calling. But I want you to know that intent element is an important element because it keeps the First Amendment alive. Because like that political case I was telling you about, the First Amendment allows us to express our opinion. And you can't just arrest somebody for expressing their opinion. The limitation on this crime is if they're expressing their opinion, it may not constitute the crime. But again, I don't think you can call a zillion times expressing your opinion. That would constitute probably the crime. There's some line there. I don't know where it is. It's a squishy gray concept, but it's out there, and people are getting arrested for harassing phone calls for any number of calls. So be careful out there.